Good evening. Hello, hello, hello. Good evening and welcome, and wonderful to see so many people here. You're all very, very welcome for what should be a very interesting discussion tonight. And I've just got a few sort of bits of housekeeping, as it were. First of all, are there people here who are not on the email list for Think Rhosneigr? There must be some, yes. Could we have a history student from Edinburgh, Henry, who is very kindly offered to gather emails. Is anyone else who's not on the mailing list, could they put their hand up so that Henry could see where to go? One at the back there. Have you got it?
You'll be spammed for life.
And one of the reasons to be on the list is that you are able to get access to the meal if you are on the list. So there's that as well. So that's brilliant. Secondly, just to pre-announce, by the way, we've got a glass on every table, which Mark is going to demonstrate, I believe. And this glass has got 20 quid in it, which is going to the roof fund. There is a glass on every table. And I think the idea is that every table could emulate this magnificent contribution, and if you could move to the right, you can see the sad story of the roof fund. Okay, good. It's towards the bottom of the jar, and hopefully if you put a few fivers... We don't have it here though, do we? No, because we don't have it tonight. So it's cash tonight, and that'd be very welcome, thank you. Right, the next thing is, we are... there was a survey a couple of years ago asking would people be prepared to make a very modest contribution to Think Rhosneigr so that we could get speakers on occasion and get them train tickets and maybe a night in a hotel to get people who might be coming a bit of a way to do a talk. And there was a general feeling that that would be okay. And I think the sort of suggestion was £1 a week or £2 a week or maybe 20 quid a year. We're hoping to do one every month on the fourth Thursday of every month. So there is going to be, once all these emails are gathered, an online vote of which will be three options. £1 a go. We'll have a sum up machine so you can do it with a card. £2 a go or 20 quid a year, whichever would suit people best. So can we have a vote on that when you'll get an email with a survey, and if you could vote, that'd be very good, and we'll just abide by the vote. Is that okay? I hope it's all right. But previously, people said they were very happy to make a small contribution, and it will help get good speakers in, hopefully. So that's it. So that's all that. So let me introduce Philip here, Philip Wheeler, who many of you will see swimming and will have seen in the village. He is Rhosneigr's leading media lawyer, without a doubt. He is advising big TV shows every morning and national newspapers every evening. He seems to work every hour that God gives him. As it happens, it's a complete coincidence, but when I worked at the BBC, I was trying to chase down a Pakistani gangster and wanted to say lots of libelous things about him, and Philip was at the BBC and was the man who was telling me I couldn't. Although, in fact, he was quite generous in his interpretation of the law to let me say as much as I could about this terrible man. So we had come across each other some years ago, but he's been working with Panorama and Have I Got News for You, and is now with some of the big national newspapers and so on. So he's going to talk to us about free speech and where the limits to it lie, and what the rules are in the United States and what the rules are here and how they differ. So we're very much looking forward to it. Philip, all yours. Free speech.
Thank you, Owen, and thank you everyone for coming. It's great to see so many people here tonight. We've got a lot of ground to cover this evening. We're going to be crisscrossing the Atlantic a few times. We're also going to be doing a bit of time traveling through the centuries, so please fasten your seatbelts and let's get ready to go. We're going to start with a story. It's a true story from the 1930s, but it's absolutely directly relevant to something of really major importance which is happening right at this moment. Now, appropriately enough, this story is set in a golf club. And this particular golf club, as well as offering the usual sort of entertainments of a nice pint of beer after your round, the two proprietors of this club, a man and a woman, so let's call them Lee and Anne, they had installed a couple of machines which look a little bit like this. They were called in those days diddler machines, but we would know them more as fruit machines or one-armed bandits. Now, it just so happens, sorry, am I?
Yeah, there you go.
Just so happens that these machines were against the law in the 1930s. Now, everybody at the club absolutely loved them, but it just so happened that at one point somebody decided that they were going to report this to the local authorities. And sure enough, our beloved Lee and Anne soon had a visit from the local PC plod, and he politely asked them to remove these things PDQ, and that's what happened. Now, this didn't go down very well with the club members, and there was one person who was so outraged by this that he reacted in the way that only a British person can. He wrote a poem, and he stuck it up on the notice board. And the poem goes like this. For many years upon this spot, you heard the sound of a merry bell. Those who were rash and those who were not, lost and made a spot of cash. But he who gave the game away, may he burn in hell and rue the day. Now, if you look closely at this little poem, the burn wasn't spelt as you might expect it, B-U-R-N, but it was spelt B-Y-R-N-E. And it so happened that there was a member of the club called Mr. Byrne. And not surprisingly, he didn't take too kindly at the fact that he was being having the finger pointed at him for having dobbed Lee and Anne in. And he wasn't going to take this lying down, but the trouble for him was that he didn't know who had written the poem. And so what he decided to do was to take legal action against Lee and Anne, the owners and the operators of the club, who had responsibility for everything that happened there, for publishing this poem, which he said lowered him in the estimation of people. And this went to court. And there were two things before the court that the court had to decide. The first one was, had Lee and Anne actually published this? They hadn't written it, they hadn't pinned it up, but there was some evidence that Anne, at least, had seen it and had just thought it was a bit of banter between the members. So that was question number one. The second one was, if it had been published at all by them, was it the sort of thing that was damaging to Mr. Byrne's reputation? So I'm going to throw this open to you to see what you think. So first of all, in all the circumstances, do you think that Lee and Anne had actually published it at all? Were they responsible for that being up there? So who's going to say yes? Let's have a show of hands.
One hand or a
Okay.
couple. Think the three. Think that.
All right, so
they're
who's going
responsible.
to say no? I'm hoping it's going to be everybody else. All right. Okay. Well, the ones that went first and they said yes, they're the ones who are right. The court did decide that they published it. All right, so the second question, do you think it actually lowered Mr. Byrne in the estimation, in the thinking of people? Do you think it damaged his reputation? Yes, let's have the yeses on that one. Okay, and let's have the people who think no. Okay, all right, so it's the ones who said no who got the right answer, because the court decided that nobody would think the less of somebody that reported a crime to the police. Okay, so Mr. Byrne won on the first point, which was the publication point, but he lost on the second point, and so our beloved Lee and Anne came away unscathed from this particular episode. Now, the second point about whether or not it was damaging to Mr. Burns' reputation is not actually the most important point. The really important point is the bit about publication and responsibility for publication. And this analogy about the golf club notice board is essentially how the law sees the internet today. So focus on that, keep that in your mind. Right, okay, we're now going to do our first bit of crisscrossing of the Atlantic. We're also going to move forward about 30 years. And we're going to go to downtown Los Angeles. It's about 1955. We're going to find ourselves on the street, on the sidewalk, outside a bookstore. In case you don't know what a bookstore looks like, there's one for you. And we're going to look through the window, and if we look carefully, we're going to see there's an elderly gentleman who is behind the counter. He's the proprietor. He's called Mr. Smith. And there's probably more than one customer, but there's one particular person who's also there, and he's going to pick a book off the shelf. And he's going to take it to the counter, and he's going to buy that book. And then he walks out of the door, as you'd expect him to do. But if we hang around for a few minutes longer, we'll see the same man come back, but he's got a bit more purpose in his stride this time. And he goes up to the counter, and this time he's not going to take the book back, but he takes something out of his pocket, and it's a police badge. He's an undercover cop. And the book that he's bought, well, I'll show you what it's this one. It's called Sweeter Than Life, and it was about a ruthless lesbian businesswoman. And this was 1956. And that was considered potentially obscene. So just a little shout out for the Rhosneigr Book Club. If you put this on your reading list for next month, that'll increase the size of the male membership, and possibly in more ways than one. So anyway, Mr. Smith, our hero here, the bookseller, he says, well, look, I'm just a bookseller. I don't know the contents of every single book in my bookstore. But the cop says, it doesn't matter. The law as it currently stands in LA says mere possession of a book in these circumstances puts you in breach of the law. And Mr. Smith was jailed for 30 days. His lawyers appeal this, and it goes all the way to the Supreme Court of the United States. And his lawyers argue that this is in breach of the First Amendment of the United States Constitution, which guarantees freedom of expression and freedom of the press. And the argument is that if somebody like Mr. Smith, a bookseller, had to know the contents of every single book that they sold, then it would just restrict the amount of books that were actually available for ordinary Americans to read. And that in itself would be a breach of the right to freedom of speech. So it was more important to have some books which were potentially obscene. Sorry, let's do that again. It's more important to have a supply of books, including some which might be potentially obscene, than to try and restrict the supply in the way that the law sought to do. So that's a pretty ballsy approach that they took, but it's something that comes from the First Amendment to the US Constitution, and that's something that will be a theme of what I'm going to talk about. So we're going to move forward now, and this is the 1990s, and we can stay on that side of the Atlantic. And this is the sort of the 1990s. It was really the early days of the internet. And it really was the Wild West. And really the regulation hadn't caught up with this new way of communicating with people. And there was quite a lot of really pretty racy stuff that was being done online. And the internet service providers, and this is in the days before Google, it was in the days before Facebook, they were also getting sued, as well as the people who'd actually written the allegedly offending posts. So in those days, you had people like America Online, AOL, if you remember that, and CompuServe, that was another one. But there were two in particular. There was CompuServe and there was one called Prodigy. And what they did was they had two radically different ways of dealing with the stuff that was on their servers. So CompuServe basically took a hands-off approach. And they just said, well, okay, we provide the environment, you post what you want, we're not going to do anything about it. You also had Prodigy, and they took a rather more sort of highbrow approach to this, and they thought, okay, well, we're going to moderate some of the content. And this resulted in some rather bizarre findings when these cases came to court. So, and a lot of these went as high as the Supreme Court as well. So with CompuServe, which took this sort of hands-off approach, well, the approach, the court's view was they simply weren't responsible for the publication of anything. It was a bit like the golf club notice board. They just didn't, it was just, it was fine. They didn't have any editorial involvement in it at all. Whereas with Prodigy, the ones that took the more, let's say, hands-on approach, well, they were considered to have almost the role of an editor, and therefore they were responsible for what was on their servers. So you got this situation, this rather bizarre situation, where people who were trying to take a considered approach to what was on their services were being punished, whereas the ones that didn't seem to care were getting away with it. So this was a bit of a problem, and the United States Congress decided it was going to deal with it. In fact, it was going to deal with a lot of the problems of the internet, mainly at this point, access of child pornography and things like that. They dealt with in a whole raft of legislation. It was called the Communications Decency Act of 1996. And it also included a section which has effectively given complete immunity to internet service providers. Almost regardless of anything they do, they've got complete immunity. It also gave them the ability to moderate content if they wanted and remove content and not be punished for it. And this essentially has given the internet the power that it currently has. And people like Google, Facebook are essentially untouchable. They have content moderation, but it doesn't matter. They're not held to be the publishers of anything they do. They're merely platforms, and they're essentially beyond the law. So that, this act, this 1996 Communications Decency Act, is considered by many to be the bit of legislation which has given us the internet as we know it today. Now, the Communications Decency Act, quite a lot of it ended up getting struck down. And this is one of the extraordinary things about the way the US system works, because the United States Supreme Court is incredibly powerful, and unlike our system, it's got the ability to knock down bits of legislation which are in breach of the Constitution. And the stuff that related to pornography, funnily enough, which was the main target of this, got struck down by Congress because, again, what they said was, the Supreme Court said, it's better to have this stuff available that adults can see if they want to, than for us to make everybody at the same level as children who might access it. So it's this idea of don't throw the baby out with the bathwater. There may be bad stuff out there. There are other ways that you can deal with it, but the better thing is to have as much information as possible to enable people to exercise freedom of thought and freedom of expression. So it's really, really quite highbrow stuff. It's very, very interesting. So let's just see how we've dealt with this. Just, we have not been completely inactive with this. About the same time we had the Defamation Act of 1996, and one of the things it tried to do was to deal with this same situation. But we don't give complete immunity to the internet service providers. We say that you can have that immunity, but you've got to have taken reasonable care in relation to publication. And in particular, if somebody notifies the likes of Google or Facebook that there is defamatory content about them, from that point, there can be potential liability. So that is the difference between us and the United States. So we do have a slightly more, let's say, tempered way of approaching internet service provider liability. Okay. So the next thing I'm going to talk about is whether free speech is a right, and if so, where does it come from? I think most people here would probably think, well, I've got a right to freedom of expression. Well, where does that idea come from? So we've talked about the United States Constitution. I'm going to talk a little bit more about this. So this obviously was the thing that brought the United States together. We'd had the War of Independence. The Brits had been kicked out in 1776. The United States Constitution was concluded in 1791. So this is a piece of law that's been in place for 230 years. And the First Amendment is a very important part of that. And it is, as I say, a constitutional right to freedom of expression. And as you've seen from the examples I've given so far, that it really does have a huge amount of clout. So and the Americans really, really value this right to freedom of expression. So the question now is, coming over to this side of the Atlantic, do we have anything similar? And if so, what is it? Well, the first question is there such a thing as a constitution for the United Kingdom? Well, the answer is yes, there is, but it's not quite the same as the United States version. So in the United States, it's one single document, and that really is the source of everything in their legal system. For us, we have lots of different sources. So there is a constitution, but you find it in lots of different places. So the first place to look is something called the Bill of Rights, which is 1688. There's a little extract of it there to show you nice copper plate script, so it's good and old. But 1688, the Bill of Rights. Let's have a think about what was going on there. Just to give you a little bit of history of this time, there were it had been a pretty troubled couple of centuries. We'd had Henry VIII, who'd basically established the Church of England and had severed the links with Rome. And there was this big running sort of battle between the Catholics and the Protestants. And you also had Parliament against the monarchy. And towards the end of the 1600s, you had Charles II, who was restored to the throne. His brother, I think it was, James II, he made the mistake of marrying a Catholic. And it looked like everything was going to happen again. And the sort of, the sides were gearing up for potentially another civil war. James II decides he's not going to fight. He fights shy. He goes away, leaves the country. Parliament decides, right, he's abdicated. And they bring in his daughter, called Mary, and her husband, William of Orange. So you have those two people who jointly ruled, William and Mary, and they were installed on the throne in 1688. And what the Bill of Rights did was essentially carve out what was going to be for Parliament to deal with and what was going to be for the monarchy to deal with. And as part of this, one of the articles in the Bill of Rights said that there should be free speech. But, unfortunately, it was limited to Parliament. They didn't put it any wider than that. So yes, Parliament has got free speech, and you can essentially say what you like in Parliament without any fear of legal repercussions. But that doesn't extend beyond it. Okay, so what else is there? Well, the UK legal system is essentially something called the common law. So I've given you a little picture of some judges there. And the way the common law works is essentially you can do pretty well whatever you want as long as it's not against a recognised bit of law. They're called torts or civil wrongs. So you'll have things like trespass or negligence. Those are examples of that. But when you're in the sphere of speech or publication, the biggest thing that is the biggest recognised tort is something called defamation, which is the bit that relates to your reputation. So if you say that something is published, so something has been published and damaged your reputation, that is within the sphere of defamation, and you can take legal action based on that. So you have the common law, and there are bits of legislation which bear on this. There are also court decisions which continually develop it. So that's the common law, and that was the way things worked up until very, very recently. Other things that might be relevant to this. Well, we've got, in the aftermath of the Second World War, there were various attempts to develop sort of systems, or let's say, guides to best practice for the states that have been absolutely smashed as a result of what had happened in the Second World War. So you started with the Universal Declaration of Human Rights, which came from the United Nations in 1948, and that established a right to freedom of expression. But this was only a sort of guidance document. It's got no binding authority on anyone, and it certainly doesn't on the United Kingdom. Closer to home, we've got the European Convention on Human Rights and Fundamental Freedoms. That's 1950. It was constructed by the Council of Europe, to which is very different, by the way, from the European Union. It's a similar name, but it's a different body. We were part of this. We helped draft this document, but importantly, we didn't sign up to it. European Convention on Human Rights has got a right to freedom of expression, but what's interesting about it is that unlike the US Constitution, it's not a standalone right. It's set against other rights. And in particular, you've got rights to privacy and other things which might compete with your right to freedom of expression. And so, unlike the US, where you've got a really powerful right to freedom of expression, it's much more nuanced under the European Convention. Okay. Anyone recognize that man? I'm sure you do. He's the man who changed it all. Because when Tony Blair's government came to power in 1997, it had a massively reformist agenda. And one of the things it did do was to bring into force, via the Human Rights Act, the European Convention on Human Rights. And this was a seismic change in the legal system, because whereas before, as I said, under the common law, you could essentially do what you wanted unless it was caught by a specific pre-existing law. The way the Human Rights Act works is to say, well, we've incorporated the various different rights under the convention into our law. All our existing law now needs to be read in accordance with that. And these rights need to be upheld. And so that has brought in lots of nuances that didn't previously exist. So yes, we do have a right of freedom of expression, which is enshrined in our Constitution via the Human Rights Act, but it's got no greater weight attached to it than any other right. So in particular, you've got the right to privacy, and all of these things need to be balanced off against each other in any particular case. So a very different system from that which is in place in the United States. Another thing about the Human Rights Act is that it made us need to take into account the decisions of this body, the European Court of Human Rights. Now, this is comprised of judges from 40 plus countries. And this is a bit of a problem, particularly for people towards the right of the political spectrum, because they don't like deferring to foreign authorities for matters that are, within our own jurisdiction. And it has to be said, there is some pretty patchy judgments that come out of the European Court. So there we are. So that's the kind of overall legal framework. So what we're now going to look at is what are the main UK legal restrictions. Okay, what are the main things which might affect your right to freedom of expression under the law in the United Kingdom? All right, so I've mentioned the first one, defamation. That's by far the biggest. And I'm going to give you a couple of beauties there. Anyone recognize those two? Mm-hmm. So we've got the two wags at war, Rebecca Vardy and Colleen Rooney. What I'm going to do with this next bit, I'm going to give you the facts of what happened. I'll tell you the way it worked under the UK system, and then we're going to see how it might have been different under the US system. Okay, so Vardy and Rooney. The story was that Colleen Rooney, wife of Wayne, obviously, was worried that somebody was leaking stories about her which seemed to derive from her private Instagram account and selling them to the newspapers. So she did this sort of like this process of elimination. She made up stories, put them on her Instagram feed. She exposed some to some people, some to others. And by process of elimination, she worked out, or so she thought, that the person that was leaking the information was Rebecca Vardy. And she put on her Instagram this long post in which she'd explain what she did, and the concluding words were, and the Instagram account was Rebecca Vardy's account. And she published this. And not surprisingly, Rebecca Vardy was pretty upset about this, and cut a long story short, she sued her. Now this went to court, and you probably know what the outcome was. But the way our system works is that it was for Colleen Rooney to prove that it was true. It wasn't for Rebecca Vardy to prove that it was untrue. So the burden fell on the publisher, Colleen Rooney, not on the person taking the legal action, Rebecca Vardy. And if you think about her case was essentially inferential. She was saying, well, I have worked out that the person it must be is Rebecca Vardy because this is how I've gone about it. She had no direct evidence that Rebecca Vardy had leaked anything at all. And when it came to the trial, Rebecca Vardy was saying, well, I didn't do it. And her assistant had conveniently dropped her phone in the North Sea, so that wasn't available. So it was a real problem potentially for for Colleen Rooney, but fortunately for Colleen, the judge basically saw through all of this and found in favour of Colleen Rooney. So she won that case. So let's look at the US approach. Now, in the US, it's very different. Again, think about this, this fundamental right that they've got to freedom of expression, which we don't have to the same extent. And in this country, it's for the defendant to prove the truth of what they've said. In the United States, it's the other way round. It's for Rebecca Vardy to prove that it's untrue. Okay? They also have something which is called public figure privilege. And so they look at people depending on where they sit in society. So you think about government officials, you think about elected politicians, but the whole definition has extended really quite a lot. And it's likely that Rebecca Vardy, or at least possible, that Rebecca Vardy would have been considered a public figure, and that places yet a higher burden on somebody taking action. You have to show what's called actual malice. You have to show, and that doesn't mean hatred or ill will. What it means is that you knew that Colleen Rooney knew that what she was publishing was untrue, or she had a reckless disregard for whether it was true or not. So it would have been a massively different legal case had it taken place in the US. In fact, I don't think it would even have got off the ground at all. So that's that one. Okay. We're going to talk, okay, I'm going to move forward a bit. So we're going to talk about privacy now. Does anyone recognize that person? Hello, hello, hello. Okay, so this is Gordon Kay. The reason I put up that slide is that there was a famous case that he tried to take in about 1990, which resulted in the conclusion that there is no, or there was at that stage, no right to privacy in the UK. The circumstances were extraordinary. He was at the height of his fame. He was driving home in a big storm. An advertising hoarding blew through the window of his car and basically hit him on the head. He went to hospital. He was almost dead. He had a big operation. And journalists from the Sunday Sport got into his private hospital and interviewed him when he was heavily sedated and took photographs of him in his hospital bed and published them. He tried to take legal action against this, but the court basically said that there was no freestanding right of privacy in the UK. If we fast forward, I think you all know who this is. 1998, the Human Rights Act brings in the European Convention. We've got the right of freedom of expression, which is one of the articles in that, but you've also got a right of privacy. Well, in fact, it's a right to respect for private and family life. And for the first time, this was used to give a right of privacy which hadn't previously been recognized. And it's resulted in people like Meghan Markle now being able to sue for, in her case, it was the publication of a letter that she had written to her father complaining about the way that their relationship had broken down. This was obtained by the Mail on Sunday and published by them. She took legal action. The question was there a breach of her privacy? If so, was it outweighed by the Mail on Sunday's right to freedom of expression? The outcome to that case was that she won and they lost. It was very sensitive material, according to the court. So, how would that be different in the United States? Well, actually, the United States was ahead of us in terms of privacy. We only got our law of privacy in about the year 2000. They've had it for 100 years or so. But again, the Constitution gives a much weaker protection to people's privacy than it does here. So here it's a balancing act between privacy on the one hand, freedom of expression on the other. They start equal. You work out from the facts of the case which one should come out on top. In the United States, you've got right of freedom of expression, which is paramount, and individuals' rights are lesser, only going to be in really quite extreme circumstances that somebody is able to recover damages for a breach of privacy in the United States. So there we are, that's that one. Interestingly, I've got this slide up here, the same article that gives us the right to privacy is also the one that asylum seekers tend to use when they're trying to avoid deportation, because it's the right to private and family life, and deportation is considered to be a breach of that if you've got family ties in the UK. So that's something which, let's say, the people on the right of politics find quite repugnant about the Human Rights Act. Right, okay, some unsavoury characters here. What I want to talk about here is pre-trial publicity. So I give these two examples. You've got, I'm afraid these tend to be really nasty people. You've got Wayne Couzens on the right, and you've got a guy called David Carrick on the left. In this country, we have a lot of sensitivity about what can be published pre-trial. You've probably heard this when you tune into chat shows, oh, we can't talk about that, it's an active case. The reason for that is the courts take a very, very dim view of publicity which could affect the outcome of a trial. And it really does have a pretty senseless application in many cases. So Wayne Couzens on the right there, I mean, everybody knows that this is the man that raped and murdered Sarah Everard. He's probably one of the worst one of the worst murderers in recent history, certainly. If you didn't know that, you've probably been hiding under a stone. You probably only recently found out that he was also charged with various counts of indecent exposure. But there was a huge amount of sensitivity about what the media could actually say before his trial for indecent exposure. Even though you might think, well, everybody knows what he's done to Sarah Everard. And it also played into this other nasty guy called David Carrick, whose nickname was the Bastard within the Met, which probably tells you quite a lot, who was charged with about 65 rapes, I think. And these two were linked because they were in the same unit of the Metropolitan Police. And the media was really warned off making any connection between Wayne Couzens and David Carrick for fear of prejudicing the trial of David Carrick. It is really quite extraordinary. How would that work in the US? Well, they've got, again, what I would say is a much more grown-up approach. And again, it's the First Amendment which probably powers this. And quite simply, they say, well, the requirement is for a jury to be impartial but not ignorant. So they can know stuff, but they can still discharge their obligations to deal with a case impartially. So they're much more willing to trust juries than we are in this country. And again, I think that probably comes from this First Amendment tradition.
Sorry, do you think that that's possible to do? Do you think like you trust people to do that, but do you think they can be impartial?
I didn't hear that.
Do you think they can be, like you're trusting them to do that, but do you think that they can be impartial?
Well,
You're up to about 45
okay,
minutes.
sure, how am I doing? Okay, we'll
Yeah, go for it.
shall I answer that now?
Yeah, let's just hear everyone can hear the question. Yeah. Okay. Well, yeah, we need to.
I'm almost done.
Okay, well, why don't you just wrap
Yeah,
up?
okay, all right.
Yeah.
Okay. All right, so let's flick through this.
Yeah.
Okay, right. Okay. So what I want to talk about now is the future, because this is really quite important. We've got a couple of things happening domestically which are really big, and something happening overseas which is also really big. So the first one is this. This is what's called the Bill of Rights Bill. It's Dominic Raab's baby. And it's it's essentially an attempt to solve the problems or the perceived problems with the Human Rights Act. It's going to give less power if it goes through to the European Court. It's going to mean that our domestic law doesn't have to be read in accordance with European Convention law. And it's also going to try and beef up the protection for freedom of expression by giving great weight to freedom of expression, whatever that means. Now, whether this is going to go through, goodness only knows. It really hasn't got very far, and it's probably going to fail if Dominic Raab falls. So that's point number one. We've also got something which is really big, which is the online safety bill, which is an attempt to try and solve all the problems of the internet. It's going to try to bring in greater protection for children. It's going to try to put internet companies under the regulation of a UK-based regulator, which is called Ofcom, which is the same body that regulates TV and radio. It's passed through the House of Commons. It's now in the House of Lords. A lot of people are saying that it's seriously flawed, but it is probably likely to become law in some form later on this year. So we'll watch that space. Right, the final thing is this one. It's back to the Supreme Court in the US. There are a couple of cases going on right this minute, literally this week. And they could, if they're successful, they could completely change the way the internet works, because they're the challenge to the protection given by the Communications Decency Act. They both arise from terrorism content, and in YouTube's case, the problem is that YouTube's very own algorithm is recommending more videos of the same type. So if you have jihadist propaganda, it's going to point you to yet more of the same, and the idea is that it radicalizes you. There's another thing, which is that these companies, as well as pointing you to new content, they're also making money out of views that you get. So they're considered to be, or at least the argument is, they're considered to be funding terrorism indirectly, because they're directing viewers to jihadist content. If this goes against the likes of Google, then the way the internet, as we know it works, will completely change. And finally, that's all, folks.
Well, I think you can see why Philip's so busy with the amount of work he's getting with this amazing knowledge he's got of the whole legal landscape of what the media can and can't say, where free speech ends, and what the limits should be in the UK and in the US. So, why don't we start with Forrest? What was your question?
Well, it was about 5 minutes ago now, so I'm struggling to remember. But it was something about, so you were saying, yeah, so people it's a more grown-up approach in America. So people are allowed to know stuff, but are trusted to discount the things that they've read. In your opinion, do you think that people do actually discount that, or do you think that they are swayed? Do you think it's a better system? Because often people believe the last thing that they read.
Okay, well, there's another thing that they're able to do in the United States that we don't do here, which is do jury surveys. So there are restrictions in this country on what you can ask people who've been on juries. In fact, it's a contempt of court to ask about the deliberations in the jury room. So we actually can't do any proper research about how juries actually go about their job. Whereas in the United States, they can do that, and it seems that they are able to do their job properly. So there is some evidence that it does work.
Thanks. I wanted to build on one that Forrest was asking, but it was about something you said about the US courts. I think I heard you say that effectively you had to prove a negative. I'm a scientist, and I know that's impossible.
Well, the negative is you have to prove that something is Let's see if I get this right. Okay, so in this country, when you're defending a libel action, the burden is on the defendant to prove that what they said was true, whereas in the United States, the person taking the libel action has to prove that what was said was untrue. So it completely reverses it.
Thanks.
So as a journalist, I must say, I came across this the whole time, and I still do, that I've got lots of stories I want to publish, but I can't, because I can't persuade my source to go into court and back me up, and to say in front of a judge, I told him this, and I believe it's true for the following very good reasons. And if I can't persuade that person to appear in court, then my story is gone, and my allegation just never gets published, which is a great grievance to me. And I think it's a very restrictive law that prevents me from bringing down corrupt people. There are lots of things I'd like to publish that I'm unable to because of libel law. And in the US, I would be able to publish those things.
We've got a, I mean,
Yeah.
we have, our libel laws here are a national embarrassment, if I can put it that way. And I'm not just saying that for the sake of it. One of the slides I was going to show you, it relates to, there's something in the United States that happened because they were so aggrieved about the ease with which people could sue in this country and get a victory. And they simply decided that judgments in this country could not be enforced in the United States. That is how bad it is. So our libel judgments do not count in the United States.
Yeah, Phoenicia.
Hi. Good talk, Philip. Well done. It's marvellous. So I've got two questions. One, do you think that the judgment came down on the right side with Colleen Rooney? Because you said it was on her to prove that Rebecca Vardy had done it, but you said that she couldn't actually provide any solid evidence. But somehow she won anyway, right? And then the second question was about, do you think that it came down the right side on the Molly Russell case against Facebook as well?
Okay, well, I thought that Colleen was going to lose. I just thought that the gap between the evidence that she was able to put forward and the allegation that she had made was too big. But, you know, it turned out that the judge took a different view. It was a very considered judgment. I can't really fault it. Phoenicia, I didn't hear the second bit of your question, so...
About the Molly Russell case, do you think that
Molly Russell?
Molly Russell.
against Facebook?
Okay. So this is the sort of the suicide. Okay.
What happened in this case?
Okay. So Molly Russell was the story is that she committed suicide because she was clearly very vulnerable, but she was accessing these these forums which were encouraging suicidal behaviour. And her family have taken on this case, and their view is that the companies are liable for what happened to her because they failed to take proper steps to protect people like her from it. There's a lot of weight to that argument, but you know, you could also say, if you go back to some of those early US cases I talked about, the better way is for the companies themselves to develop systems to stop that sort of thing happening than to have really heavy-handed legislation which prevents everybody getting hold of the content that they want. So there's a lot of bad stuff on the internet. Everybody knows that. There are ways that you can minimize that coming to people's attention. But it's better to have some rubbish like that, but have everybody access as much as they can freely than to punish everybody.
Do you think it would have gone differently in the States?
In the States, would have that gone differently?
Oh, in the States, I simply can't answer that question. I just don't know.
Gus.
Philip, thank you very much for your very erudite talk. In your preamble, I noticed in the same sentence you referred to lesbian women. Now, is there something that most of us baby boomers don't know about, or can you enlighten me, or anybody else in the room? Is this a nod in the direction of the sort of non-binary situation?
Are you pandering to the transgender?
Oh gosh. What did I say? That was the
Lesbian women.
oh, lesbian women. Okay.
It's a fine point.
Right, okay.
Roger. Save us, Roger.
Good point, well made. Can I just remind everybody that we're trying desperately to record this for posterity, so if we can make all our comments over the microphone and just take our turn to make the comments, that'd be brilliant. Thank you very much. Roger.
I just wanted to get the microphone away from Gus. Great piece, Phil. Thank you. All a bit too legal for me, I'm afraid. A lot of it just over my head. I couldn't really follow a lot of it, but that's just me. I'm sure everybody else did. But yeah, I think you need the microphone. What I wanted to ask is, is this censorship, is this freedom of speech, can it be retrospective? And I'm talking about the Roald Dahl recent news of having kind of retrospective censorship of published material. And is that just a load of literary boffins doing this, or is that a legal event that's happening? And I'll just throw in, because I'll probably not get another go now, I'll just throw in Delilah, which is quite an important and topical case of freedom of speech, I guess, in that I thought, well, what a load of rubbish that is, taking that out of the on Saturday, tomorrow, isn't it? They're going to be singing it, or they should have been singing it. And then I heard a lady who said that there are 2 cases per week in the UK of women getting stabbed by their husbands for philandering, which is what the song's about. And that kind of brought it a little bit down to earth for me. Can these things be retrospectively censored? So then you can look at every book in the world, can't you?
Two recent cases, because in the Roald Dahl case, I think it's the word, well, there's lots of words have been excised, but one of the most controversial is the word fat has been removed and replaced with enormous or something like that. Yes. So is that a legal requirement?
No, it's not.
Yeah, and in the States, it just wouldn't happen.
No, well, all I can say is the changes to the Roald Dahl books are UK only, so it's Puffin Books who publish Roald Dahl's work in the UK, and they're the only ones that have done this. It is extraordinary, but I mean, you can argue this lots of different ways. I mean, I suppose you could say that if you allow in the argument that if you're overweight, you can be upset and your comfort is interfered with by reading stuff, these disparaging descriptions in a children's book of somebody being fat, then, if you allow that argument in, then it opens the door to this sort of thing, this retrospective rewriting of somebody's work. You don't have to do that. I think it's pretty extreme, but you also have to recognise that there are instances where, stuff that was done previously, you just would not do now. So, a classic example is an Agatha Christie book. It's now known as "And Then There Were None," but when it was first published, it was 10 little N's. Yes. Now, in the United States, it was first published in 1940, and they didn't go with 10 little n, they went with "And Then There Were None," which comes from the same rhyme. We kept that in the UK until 1985. But I don't think anybody now would think that that was the wrong thing to have done, to have changed that title, because that word is so offensive to the group of people concerned. And another example is, you know, the cartoons of the Prophet Muhammad, you just, you know, whether it's legal or not to publish them, you just don't go close to it. So I think there are, you know, there are real reasons why you might not do things based on cultural sensitivities. My personal view is I think that Puffin got it massively wrong.
With the Roald Dahl.
Yes.
Question, Charlie, yeah.
I'm just going to ask a question about SLAPS, this law that allows very, very wealthy people from wherever they are around the world, including Russians, to come to this country and basically stamp on anybody who is investigating them and has things to say about them.
Slaps, yes. What can I say about slaps? It's I come across this quite a lot. The difficulty with slaps is what is or is not a slap. There's no formal definition of it. It's a sort of a perception, I suppose. Every lawyer is going to use tactics which maximize their client's case. Some of those might be distasteful, but they might be legitimate. Now, a lot of these things which are called slaps, I don't think are all that bad. That, you know, they are taken by, you know, really, you know, heavy-duty claimant law firms, but they're acting within the law, and you know, their tactics might be distasteful, but
so these are basically letters from lawyers saying, if you publish this, the world's going to fall in, and lawyers do that. Yeah.
Yes.
Yeah.
Because your job as a lawyer is to get the best result for your client. I mean, I don't think that's necessarily problematic. And you know, these. So, for example, there's a book about, it was Putin's People, I think it was called, which is, and then there was a whole load of Russian oligarchs that sued the publishers and also the author of that book. And that's widely been described as being a slap. But on the other side, they did get passages changed. So it wasn't as if it was a case that was without merit.
So I guess the journalist's perspective on that is that there's nothing worse than getting a letter before you've even published, terrifying your editor into caving in, and you want to publish. And you know, these editors get these letters and think, well, it's easier not to, and let's let it go. I mean, that's the danger. The journalist gets shut down, basically. Yeah.
Thank you very much for your lecture. It spiked all sorts of memories for me. I had several run-ins as a college librarian with the copyright officials because we had a photocopying machine. And I used to stand and say, you are allowed one copy for study and research. But of course, our students were copying whole books, things like statistics, which were unpublished, but tremendously expensive. And so, of course, there were lots of run-ins. But I came to the conclusion that copyright law in this country, they weren't all singing from the same hymn sheet. And it depended who you talked to, what the result of your argument was. And also, do you remember Robert Maxwell's biography, which was withdrawn as soon as it was published because he didn't like it, and the spy catcher thing.
Yes.
All these books, you know, I had to send back because they weren't allowed. So that was all very interesting. Going back to Roger, always is on the same wavelength as me. Roald Dahl, and I was horrified that they are rewriting his books. And I'm glad that the French publishers decided not to change it. I mean, when you start taking words out like that, I mean, how far are they going to go? They're on a slippery slope. What would Thomas the Tank Engine be like without the fat controller? What would Winnie the Pooh be like if Winnie the Pooh was not allowed to be fat?
Yes.
And as far as I was concerned, as a child, I was far more emotionally disturbed by Oliver Twist and David Copperfield. I couldn't understand why adults were so cruel and beastly to children. But that was, considered all right. Whereas the lovely books that we used to really enjoy because they were horrible and said nasty, spiky things, those are considered not okay now. And this worries me.
Yes.
Because after all, words are just a collection of letters. It's the context in which you use words. For example, my husband, when sorely provoked, would come out with, "Oh, Christmas!" and we knew that was like blasphemy. But Christmas wasn't sort of prohibited. I think we get a bit uptight about language. Language changes, and we should leave published material as it is.
I totally agree with you, but except the point that I made, that there are certain things. I think the Agatha Christie book. I do think that was the right change to make, because I think that is such an offensive title to have.
But it's offensive because of the context in which it's used.
Well, it's shorn of context, isn't it? There's no context to a title. It's just, it does come across as a, I don't know. I mean, I can see why that happens with the Roald Dahl stuff. I do think that the more offensive thing is the changing of. It's not just deleting a word here and there. It is rewriting wholesale passages of it. So that's not any longer Roald Dahl's work. That's the problem. And I do think there's with art, art is, it's I wouldn't say it's sacrosanct, but it's got to have a higher value than other types of output. And to change an artist's creation in the way that they've done without decent justification, I think is really, really difficult to justify.
I don't know if people heard the Today programme the other morning when Philip Pullman, another great children's author, basically supported the changes to the text. It was quite striking. Yeah.
You talked about the US jurisdiction, UK. I think one of the challenges is legislations are national, the internet is international. How do we ever solve this when you're talking about not just 2 jurisdictions, but 206 jurisdictions or what have you? And is there anybody who's getting it right?
Cool. Well, to answer the second question, first of all, I don't know if anyone's getting it right. I think it's so difficult to think of a way that you can regulate the internet that is not going to really restrict it and make it different from what we have now, which I think is and what the internet has done is basically democratize publication. Before it used to be the likes of Rupert Murdoch that had control over what people put out. Now anyone can do it.
But it does go. I was reminded.
I think would be really, really drastic.
But it does go back to, I was in Australia when Skycatcher was published, and I could have bought a copy at Sydney Airport, but I wasn't allowed to own it or buy it when I landed at the other end of the flight. So I think it predates some of the internet, but I think that's made it more exaggerated.
Yeah. I mean, Godot's puts you, the obvious thing with social media is to end anonymity of people being able to post stuff without being clear who's posting it. Now, in any other form of publication of any widespread nature, you know who's publishing, you know who's writing it. Wouldn't that be a regulation that would avoid quite a few of the harms that are coming out of social media?
Well, I mean, they could almost certainly do more. I think the better route is, or my personal view is, the better route is to encourage the companies to make that a policy rather than to impose it as a law.
Good evening, gentlemen. As a lawyer and a journalist, I would just like to get your thoughts on the case of Julian Assange, please.
We've had Julian Assange. What?
Yeah, about the Julian Assange case. Yeah, we've had a discussion tonight about the freedom of speech, and I would say that is the most publicised case of freedom of speech going on at the moment, right? What's happening to Julian Assange? So I'd like your thoughts on it, please.
Okay.
And the WikiLeaks releases, and this might be a little controversial, but it is.
No, it's
the whole
not.
case
Okay,
is about free speech, isn't it?
Yeah. I think the first question is so big. What's my thought about Julian Assange? I'm not, not quite sure how to answer it. What I will say about WikiLeaks, they did a lot of.
What do you think he's done from the lawyer's point of view?
What's he done from the lawyer's point of view?
Yeah, was he correct in his
Was he correct to publish?
The
was he
problem
not?
with the problem with what he did was the lack of filtration of what was put out there. There was material that was going to compromise very exposed people, and that happened. Well, it's my understanding. So the way that professional publishers go about things is that there are processes which are followed. I'm part of that process for newspapers. Editors oversee what is done. My understanding, I wasn't involved in that, so I've got no direct knowledge, but my understanding of the Julian Assange WikiLeaks stuff is that this material was obtained and just dumped. So there was no sort of filtration of what was a good thing to publish and what was a bad thing to publish. So there's got to be some responsibility editorially for what you put out.
Yeah.
I just wanted to, and this is probably de-escalating a little bit from the Julian Assange thing, but with the Roald Dahl stuff, it occurs to me that there's something quite interesting in how we immediately raise that as an issue here, when that strikes me as fundamentally like a very different question, because that wasn't a legal challenge posed to Roald Dahl, like, are you allowed to write this thing in the past? That was his estate, as far as I'm aware. It was his family choosing themselves to, with their full, intellectual ownership of that property, to say, no, we are going to publish it, for our benefit, for our profit, in this particular way, which strikes me as a fundamentally very different set of dynamics and ethics and questions, legally, otherwise, to what we're saying about heavy-handed government, etc. This is a very different thing. In fact, if anything, it strikes me that the side that everyone here was kind of gravitating towards was actually maybe a heavy hand coming in to say, like, no, you don't own this particular thing. This is a collectively owned bit of culture, which we, as a society, are deciding how is going to be propagated. Anyway, that's it.
Okay. I mean, I would accept that they've got the right over the estate to do what they did, but I think that's separate from whether they were justified in doing it. And they clearly have taken the view that they need to distance themselves from Roald Dahl the man, and it perhaps is the case that part of this is by making retrospective changes to what he originally wrote and what was originally published. I think those are different considerations.
I mean, if you publish something today, if you republish something that was written 100 years ago that would today be categorized as hate speech,
yes,
would that get you into legal trouble? Yes.
Yes, but I mean, I think you'd have to say it would be quite difficult to think of what the circumstances would be.
Yeah.
But I mean, for example, I think Mein Kampf, you wouldn't not publish that in its original form. You need to know what it said.
Yeah.
Just in passing, how does that type of comment fit with, for example, statuary of people who have been part of our culture and celebrated, but now can be seen to be slightly wanting in terms of the way we think about things now?
I agree. It's a very similar set of circumstances. I'm not quite sure how can I mean, you know, I don't think I'm up here to defend my own personal views or to put a manifesto out.
No.
But you know, you can see that in my position, I've got to be in favour of publication. I've got to be in favour of, you know, the maximum possible ability for people to, you know, to see things and be exposed to things. So freedom of expression, freedom of thought, are you know, they're massively interlinked. And you know, the argument that you can that it's okay to take public monuments and put them in a museum and have the same effect, I just think that's so misconceived. They are what they are. They're not intrinsically offensive. I don't think one needs to put new material on the statue or around the statue to educate people, but you can if you want. There are ways that you can understand things. You can, you know, if you're interested in a statue and who that person is, you can research it. I don't think it has to be rammed down your throat. That would be my view.
Bobby.
Well, going back to Roald Dahl, I obviously have no idea what the family and the estate had in mind, but I suspect they were seeing that the estate had an enormous intellectual property there that was children's entertainment that inspires, you know, many countries and cultures and is very powerful, and that they could see that there were offensive elements of it that they wanted to eliminate, and it was probably a simply commercial opportunity to inspire the legacy for duration.
Well, more specifically, I think it's been suggested it was because there's a big Amazon Prime Roald Dahl series about to start.
Well,
and
yeah.
They're trying to clean it up before.
Well, rest my case then. That's all I can say.
But I think I would say that would be different because, you know, when you televise something or when you adapt it for the screen, of course you can you know, interpret it in the way that you want. But I do think it's very different from rewriting the books themselves. And apparently, I thought it was Netflix who bought the estate. Well, they certainly bought some of the rights to the estate. But this is happening in the UK. This is Puffin only. So I don't think that argument works.
Brett, you yep.
Thank you, Philip. Very interesting. Didn't expect to enjoy that, but I did. Defamation of character.
Yes.
Does that have to be written?
No.
Right. Now, the last one that we had here was Sean, and he got a right blagging on social media from some troll. Not quite death threats, but getting along that way. Would that be a defamation of his character?
Well, I mean, it depends what's said. You can only look at these things and work it out, and I'm afraid that's why people like me exist. We look at
you
stuff.
You mean we've got to pay you then?
we look at stuff and we work out what the issues are and whether there's anything that needs to be or can be done. So I couldn't possibly comment on that, but you know, happy to look.
I'm still here, don't worry. Enormous as I've always been.
With my inexpert eye, I didn't see anything actionable. No.
Forrest, yeah.
Sorry, I forgot to say that I enjoyed your speech before, which I did. I've got a question about Roald Dahl. No, I haven't. So recently in my echo chamber, I've seen a few judgments between co-workers where disagreements have ended up being with a judgment of something being construed as banter by the judiciary, whoever it is. And previously to that, I'd often thought that judgments would have gone against the accused, as it were, the banterer. And now I feel like more often I'm reading about the things being just sort of passed off as normal office behaviour. Do you feel like there's maybe a slight swing towards that now, a sort of more common sense view potentially of office interactions, or do you just think that that's maybe just a swing in the media recently where they're now reporting more? Because banter, I would say, is sort of freedom of speech. I can say what I want as long as it's in a good,
I'm
good-natured
interested
way.
to hear that you think that it's, you know, it's going the way that you think it's
Well,
going.
yeah, just recently I've read a couple of things which I was surprised about.
I don't, you know, I don't know if it is. One of the things I did think about, including in my talk, was you know, it's really quite a difficult one to talk about, but maybe I can air it now. But it stems from the sort of Wayne Couzens situation, where, you know, you've got this person who is, you know, he is involved in a heinous crime, and then the whole focus becomes, what could we have done to stop him? What signs were missed? And as part of that, they sort of, you know, they get hold of his phone, and they find out that he's involved in WhatsApp groups, and there's lots of sort of banter, which is, you know, flying around between him and various other police officers. And as a result of that, various people have been, you know, they've been prosecuted for something called misconduct in the public office. And I find that really, really difficult, because, you know, these are private groups, and people do say, you know, I mean, they say stuff in private groups that they simply wouldn't say in public. Now, for me, that's the state massively overreaching. I'm not saying that we can, you know, I'm joking about, you know, victims of crime and, you know, rape victims in the way that they did. No one's going to say that's a good thing, and it's not a good look at all. But whether it's a crime or not, I think is a really different question. And again, I don't think that would be allowed to happen in the United States.
I'm asking for a friend here, but so those people who made probably, I haven't seen them, but probably very unpleasant comments, if they had been builders, for example, and had a conversation about that, would they have been in trouble? Was it simply because these people were policemen?
Correct.
Yeah.
Yeah.
So for example, an RAF officer plucking an example out of the air, if I had said something like that, would I be in trouble because I am in a public office?
Well, I mean, you potentially would be in the jaws of that, yes.
Yeah. So
I mean, I'm not, you know, I don't practice in the criminal law, so I don't.
Yeah,
know.
yeah, fair enough. It's just interesting that someone in two different situations can be.
You know, that I think is a really, really difficult situation where private communications not taking place in a work context suddenly get brought into, you know, they get brought into the public domain, and people lose their jobs, or they even lose their liberty because of that. I think that's really hard.
Okay, we got
just
one more
quick one.
No.
What I really mean is, what I called Forrest fat the other day, and I meant to say you were enormous. I'm sorry.
He's nothing like either. One quick from Roger.
Is this the last word?
Got a quick thing on the banter thing. Tiger Woods handed a tampon to his playing partner, and this was locker room banter, but nothing was actually said, but it was caught on camera. But actually what it was an insult to every female on the planet. And it was that the banter was to say that I've driven further than you. So he handed a tampon to his playing partner, who was not offended in any way, and it was banter between them. But caught, so nothing was said and nothing was published, but this event was caught on camera, and well, we know, you know, there's an uproar. So that's not a legal matter, is it?
No.
That's just a journalism matter.
Yes.
Oh.
All right. Well, look, thank you very, very much, Philip. It's been an absolutely fascinating discussion, and we're very grateful for your knowledge and your very clear explanation of how it all works. So thank you very much indeed. And I think we've got some those who've paid, those who've been on in the emails and paid for the food. That is, I can see it there waiting. So over to you.